Good morning, everyone, and welcome to our 2025 annual property update. Thank you all so much for taking the time to be here this morning with us, whether you're here in the office with us or you're watching online. Usual couple of housekeeping issues first. We aren't expecting any fire alarms, so if you do hear one, the team will make sure that you are safely evacuated. Just a reminder also, please to switch off all your mobile phones. The seminar this morning should last around 45 minutes or so, and please do feel free to stay around for a coffee and another chat if you've got any questions to ask us. If you're watching online and you've got any questions, please do get in touch with us after the seminar, or you can also drop a question into the Q&A box on Zoom, and we'll get back to you after this morning. So, this morning, we're delighted to be joined by two very special guests. We have Shem Sheikh, who is a barrister with King's Chambers, and Alan Nichols, who is a very experienced chartered town planner. Shem and Alan are going to update us on some extremely topical areas of planning law and policy. So Shem's going to start by discussing the proposed changes to planning legislation, and then Alan will focus on the significant changes to planning policy for the Greenbelt and housing. These are obviously extremely relevant topics in the context of the government's pledge following the election last summer that they will build 1.5 million homes in the country in the next 5 years. It's something that the industry continues to say is going to be very difficult indeed. The new Housing Secretary, Steve Reed, very new Housing Secretary, has insisted the government is absolutely committed to achieving it. We talked this time last year in our update about the proposal for brownfield passports and the loosening of the Greenbelt to facilitate the proposed development. And Shem and Alan will update us on where things are at 12 months on. So planning's obviously not the only political hot potato at the moment. We'll start this morning by hearing from our very own Head of Property Litigation, Laura Pyle. She's going to talk about the surprise proposal the government announced in July that upward-only rent reviews should be banned in all new commercial leases in England and Wales. I think it's fair to say this was a bit unexpected and it hasn't been entirely welcomed by the property industry as a whole. So Laura's going to take a look at the proposals and also have a think about what this impact could be on the market. Laura's also going to talk about the current status of the Renters' Rights Bill and then have a look at some of the interesting cases which have happened over the last few months. The budget this year is on the 26th of November, which is much later than usual. And obviously we're going to have to wait even longer than usual to hear what the Chancellor has in store for us. Speculation has already begun, of course. Lots of rumours, including the reform of property taxes. So there's a talk of the proposed potential eventual replacement of stamp duty land tax and replacement of it with a tax on homes worth over 500,000. There's also a suggestion that the exemption from capital gains tax for people selling their main home is going to be taken away if that home is worth more than 1.5 million. We will, of course, have to wait and see what actually happens, and no one can say for sure what effect that might have on the property market and the wider economy as a whole. But I think the much later date really isn't going to help to stabilise what's still a very, very sensitive market. So it's now over to Laura to start the proper business of the day. And she's going to start with rent reviews.
Yeah, thank you, Jo, and good morning, everybody. So today I'm going to talk about, as Jo's already said, the proposed ban on upward-only rent reviews. I'm going to have a look at the reform of security of tenure, the Renters' Rights Bill, and then a couple of cases that have occurred recently. So first of all, let's have a look at the proposed ban on the upward-only rent reviews in UK commercial leases. So on the 10th of July, the English Devolution and Community Empowerment Bill was introduced to Parliament. And whilst this bill is mostly concerned about devolution, it also includes a proposal to ban upwards-only rent review clauses in all new commercial leases in England and Wales. Upwards-only rent review clauses have been favoured in the industry because they provide landlords with an element of certainty as to what the rental income for the property will be during the term of the lease. Normally it means that the rent is either increased or remains at its current level, so if the market rents go down, the tenant continues to pay the same amount. So why is there a proposal to ban upwards-only rent reviews? Well, the reason the government's introduced this legislation is because it feels upward-only rent review provisions have kept rent artificially high and have contributed to business closures during economic downturns. It appears the bill is intended to support small retail businesses, but in reality, it's wide-reaching and as currently drafted will apply to all commercial properties. It's not limited in any way to retail properties, for example, and would include offices and other commercial properties. So what's being proposed by the bill? Well, it proposes to prohibit rent review clauses that only allow upwards-only rent reviews or ones that guarantee a minimum increase in rent in all new commercial leases. There are some exceptions in the bill, so fixed or step rent increases that are specified or determined when the lease is entered into will be okay, as are provisions that allow rent to be reviewed both upwards and downwards. So what leases will this apply to? Well, it's going to apply to all new commercial leases in England and Wales that fall under Part 2 of the Landlord and Tenant Act 1954, which are essentially business tenancies. It's important to note it will apply even if the lease is contracted out of the security of tenure provisions. It will also apply to all renewal leases and put options where a landlord can require a tenant to take a new tenancy. Existing leases will not be impacted. It's only new leases and renewals granted after the legislation is effective. Leases granted under contracts entered into before the bill comes into force would also be excluded. Now, as currently drafted, the bill contains anti-avoidance provisions to prevent parties from attempting to circumvent the legislation, for example, by having a side arrangement requiring the tenant to pay an increased rent. And should the proposals become legislation, then it will have implications for investors and landlords, particularly in relation to income stability and long-term planning. It's likely that landlords are going to favour short-term leases contracted out of the 54 Act so that they can set the market rent at each renewal. Alternatively, they'll want to incorporate fixed and stepped increases in rent during the term to get greater income predictability. Now, tenants will clearly favour the proposals because if they have an upwards-only rent review, then in a downturn they can end up paying above market rates unless they're able to operate a break clause or renegotiate the terms. Now, it's worth noting that England and Wales are not the only jurisdiction dealing with this issue. Ireland banned upwards-only rent reviews in 2010, and other countries such as Australia have also done something similar, but with retail leases only. Now, the bill's in its very early stages, but the initial reaction from the industry is somewhat mixed. Certain trade bodies have welcomed the changes, whilst others have warned that the proposals will cause issues with investor confidence, which in turn could impact property valuations and lending terms. Now, the challenge for the government will be to balance supporting businesses that are struggling whilst maintaining confidence for investors in the UK property market. So next, I'm just going to touch on the reform of security of tenure. Now, I think we've spoken about this in previous seminars, but I thought it'd be worth having a quick recap. So the government have looked at reforming the Landlord and Tenant Act 1954. Stage 1 of the consultation involved a review of 4 potential models of security of tenure that could be provided by the Act. And that consultation period closed on the 19th of February 2025. And the Law Commission issued an interim statement outlining its provisional conclusions in relation to those models. The preliminary conclusions are that the current model that allows for contracting out of the Act is the right model in terms of achieving a balance between tenant protection and landlord flexibility. The existing list of tenancies excluded from protection of the Act remains appropriate and should not be extended to include agricultural or mining leases. And then thirdly, the threshold for tenancies benefiting from security of tenure could be increased from 6 months to 2 years to take into account the fact that most commercial lettings are now short-term in nature, and increasing this period will give more flexibility to the lettings market. Therefore, if the reforms are enacted, a business tenancy of 2 years or less would not have security of tenure under the Act. This is going to be assessed in stage 2 of the consultation. So the consultation committee has now moved on to stage 2, where they look to address how to make the chosen model more efficient. In particular, they will consider the technical detail as to how the contracting out procedure may be reformed. It's also envisaged that at this stage, they may look at reforming areas such as the Forum for Resolution of Disputes under the Act, the grounds of landlord opposition, statutory compensation, and the terms of the new lease. And once we have more information on this, we'll obviously update you in the usual way. So then I thought I'd just touch on the Renters' Rights Bill. So the Renters' Rights Bill has been discussed many times previously. This is the legislation that is going to transform the residential letting market and abolish no-fault evictions and the service of Section 21 notices. Now, the current position is that with this bill is that the Lords proposed various amendments to the bill, but on the whole, the government rejected what they said and they favoured a more tenant-friendly bill. The government has stressed that royal assent be given as a matter of priority. But to bring the bill into force, it's going to require commencing legislation, and there's currently no date that's been provided for this. The bill won't become law until it receives royal assent, so the current position remains the same, namely that Section 21 notices can be served, but it's unlikely to be the case for much longer, as we are expecting royal assent to take place later this autumn. And we'll update you as soon as that happens. So now I'll move on just to talk about a couple of cases. So the first case is the London Trocadero matter and Picture House cinemas. So Picture House was a tenant in the Trocadero Centre in London, and from the premises it operated a cinema. Some pictures on the slides so you can have a look at what it looks like. Under the terms of the lease, the landlord was required to arrange insurance for the whole of the centre. The landlord did this by obtaining a block policy, and it recovered the cost of the insurance from the tenants through the insurance rent. Now, unbeknown to Picture House, the landlord had asked its insurers to pay its broker's commission for obtaining the insurance policy. And in doing so, the insurance premium was increased to take into account the broker's commission. The landlord then passed on the cost of the increased premium to Picture House through insurance rent. Picture House would pay the insurance rent, along with all the other tenants in the building, and the landlord would keep the commission. Now, in this case, the tenant noticed that the landlord had been charging the tenant the insurance broker's commission and brought a claim, arguing that the landlord could not recover these sums under the terms of the lease. The terms of the lease said that the landlord could charge insurance rent, which was to be calculated as the premium payable for keeping the centre insured. Now, the court determined that the landlord could not recover the commission as part of the insurance rent from the tenant, and the landlord in this case had to refund significant sums to the tenant. Now, why have we included this case? Well, it's a warning for all landlords and tenants to check the wording of the lease. Each case will turn on its own facts, and it's important to ensure that the sums being charged to the tenant can be charged pursuant to the wording of the lease. And in this case, the court found that it wasn't wide enough to include the commissions. So if landlords want the ability to charge for commissions retained by them, then they need to be contractually agreed with the tenant. Many tenants will be unaware that landlords were earning commissions in this way and could be well advised to check the terms of the lease and ask for information from the landlord on what sums they're being charged and what it includes. Now, it's clear from this case that tenants may well have a claim against their landlords to recover any sums that the landlord's not contractually entitled to charge for under the lease. So the final case that I'm going to look at today is Kiko UK Limited and Jamino Limited in liquidation and another. So I've decided to include this case because it's an interesting case to see the court's approach when considering a former tenant's liability under an authorised guarantee agreement. So what were the facts of this case? Well, in November 2016, Kiko entered into a commercial lease for a unit on Oxford Street in London for a term of 10 years. In September 2019, Kiko assigned the lease to Jamino. Jamino is a subsidiary of Pianoforte Holdings, SPA. The tenant, assignee and landlord entered into an authorised guarantee agreement whereby Kiko guaranteed to the landlord that Jamino would perform the obligations contained in the lease. At the same time, Kiko, Jamino and Pianoforte entered into a guarantee and indemnity agreement whereby Pianoforte, Jamino's parent company, guaranteed to Kiko that Jamino would pay the rent and perform the covenants in the lease, and if they failed to do so, that Pianoforte would perform them. Pianoforte also provided an indemnity which included costs or liabilities of Kiko under the authorised guarantee agreement. Jamino, the incoming tenant, started to suffer financial difficulties and said Kiko was liable to pay the landlord the rent and fees. Kiko asked Pianoforte to indemnify them under the terms of the guarantee. In July 2022, Kiko, Gemino and Pianoforte entered into a settlement agreement in relation to Kiko's liability under the authorised guarantee agreement and Pianoforte's liability to Kiko under the guarantee. The settlement agreement provided Pianoforte a reduction in its liability of around £170,000 and that they would pay the balance in instalments. In May 2024, Gemino went into liquidation and the lease was disclaimed by the liquidator. However, the lease was deemed to continue as between Kiko, Pianoforte and the landlord until the landlord required Kiko to enter into a new lease. Given that liabilities were continuing to accrue, Kiko sought to recover these from Pianoforte under the guarantee. In July 2024, the landlord required Kiko to enter into a new lease pursuant to its obligations under the authorised guarantee agreement, and that was entered into in November 2024. Kiko issued a claim against both Gemino and Pianoforte for the losses it suffered as a result of Gemino's failure to perform its obligations under the original lease. In January 2025, Kiko obtained summary judgment against Pianoforte for part of its claim for just less than £970,000, plus just over £70,000 in interest, and the rest of the claim went to trial. So the court found that Pianoforte were liable to reimburse Kiko for sums paid to the landlord. It found that the settlement agreement was unenforceable for lack of consideration, so Pianoforte were not entitled to the discount that had been agreed. And Kiko's obligation to take a new lease under the authorised guarantee agreement did not arise as a result of Gemino's failure to perform its obligations under the original lease. Instead, it came from the liquidator's decision to disclaim the lease. So Kiko's damages for the new lease were dismissed. So some takeaway points from this are that, generally speaking, guarantors' rights and obligations are unaffected by the disclaimer of a lease under a time when the landlord recovers possession of the premises. It also highlights the importance of the parent company guarantee and indemnity clauses, and it shows that when a tenant assigns a lease and signs an authorised guarantee agreement, that it's often not the end of their involvement and liability. So that's it for me today. So thank you for listening, and I'll now hand you over to Shem.
Thanks, Laura. Morning all. I'm going to talk a bit about the Planning and Infrastructure Bill this morning. So I'm going to give you a bit of an update as to what's going on in the planning world more generally, and then look at some of the proposed changes. The bill is currently going through both the House of Commons and it's gone to the House of Lords already. There are a number of changes that are proposed under this bill. I'm going to focus on and give you a few headline points on all of them, although some of them obviously will be less relevant than others. So I'll focus on those that might be a bit more relevant than others in a bit more detail. So we know that the background to this bill is that it's central to the government's plan to get Britain building again and to deliver economic growth. And it's in the context of lots of changes to the planning system at the moment. We have the recent new iteration of the National Planning Policy Framework, which was from December 2024. And Alan's going to touch on some of those policy changes, including things like grey belt land. We've got some updated planning practice guidance on green belt and brownfield land that reflect some of the changes in national policy. Last week, we had an update to the planning practice guidance on flood risk, which changes what's called the sequential test, the approach you take to look at whether other sites are reasonably available and less prone to flooding. We've got further updates incoming on viability. And then we've also got consultation at the moment on what is called National Development Management Policies, which is a new type of policy that's proposed under the Levelling Up and Regeneration Act 2023 that came into force last year. So just working through some of the changes, as I say, some of these relate to very large-scale infrastructure known as nationally significant infrastructure projects, or NSIPs. And I'm just going to touch on some of those points. So firstly, the national policy statement reviews. National policy statements are the national equivalent of the National Planning Policy Framework, but for NSIPs. And they are historically very irregularly updated. So the last update was in 2011. And there has been an update this year in July. But the idea of the bill is that there is a requirement, or there will be a requirement, to update them at least every 5 years. And the point is, in order to have NSIPs going through the system quickly and efficiently, we need up-to-date policy, and historically that hasn't been the case. So one of the required changes will be updating the NPSs every 5 years to ensure they reflect government strategies and are up to date. We've got the second point. That should be number 2 rather than 1. I don't know whether they're all 1. Number 2 is that there'll be a disapplying requirement for development consent in some situations. So as a bit of a background, nationally significant infrastructure projects are dealt with under the Planning Act 2008. Lots of development is dealt with under the Town and Country Planning Act 1990, and that's probably more where you'll deal with smaller scale, even major development that isn't quite at the threshold of NSIP. Any development that is an NSIP has to go through an examination in order to seek development consent, and it's a type of secondary legislation. So if consent's granted by the Secretary of State, a development consent order is granted. And the idea behind this proposed amendment is that following feedback from infrastructure stakeholders, the intention is to allow the Secretary of State to give a direction on a case-by-case basis that an alternative consenting route could be used, but it would need to be quite clearly explained why that alternative consenting route was sought and why it would be appropriate for the development for any particular case. The third, and again I'll touch on this briefly in respect of NSIPs, is a change to consultation requirements. At the moment the consultation requirements are quite robust, and they require quite a lot from developers. They're also slightly ambiguous, which means that developers have taken a gold-plating approach, where they try to ensure that they've done above and beyond what's required just in case. And the idea from this proposed change is that a number of consultation requirements will be reduced and watered down. A number of consultee groups will be removed as part of the pre-application stage process. Again, just focusing on 4 and 5 in the context of NSIPs. The idea behind 4 is that it will be made clearer that an examining authority who's looking at an NSIP can make an order for costs at any time after they've been appointed, including where an application's withdrawn. And the idea behind that is that it means that developers are not persuaded or encouraged to simply put a pre-application or application in for a DCO, a development consent order, and not be aware that actually costs could be awarded if they later withdraw it. And the 5th, again in respect of nationally significant infrastructure projects, is reducing the number of stages that in respect of legal challenges. At the moment, it follows the typical judicial review process where you need permission on papers, and then if you don't get permission, you have what's called a renewed oral permission hearing, and then you go to your substantive hearing in the High Court. And the idea behind the suggestion at number 5 here follows Lord Banner Casey's review into the legal challenges brought against NSIPs, and the idea that that could be reduced and sped up if, instead of having multiple permission stages, that was all reduced to just have one oral permission hearing, which is already in existence in other respects in relation to challenges brought under the Town and Country Planning Act, so it wouldn't be entirely alien. I then spend a little bit longer looking at 6, 7 and the next ones on the following slide, because they relate a bit more to regular development and more common development under the Town and Country Planning Act. So the SIP changes planning applications made to your local planning authority. There have already been some increases to fees that have come into force. They came into force in April of this year. But at the moment, local planning authorities don't have input into the level of planning fees charged to applicants, which are set nationally by the Secretary of State. And that means that where there are variations in costs for different local authorities, they can't recover them. And at the moment, there's an estimate annual overall shortfall of about £326 million for the costs. The result of that is that local planning services are slower, less well-resourced, etc. And the idea behind this proposed amendment is that the Secretary of State will be able to further delegate the setting of fees or charges to local planning authorities, meaning that they can set fees at a level reflective of the costs for carrying out their planning and development regulation functions. And there will be a cap up to the amount that they actually spend on planning applications, so reviewing, determining planning applications. But the overarching point under this is that fees for planning applications are very likely to increase under this bill because of the annual shortfall we have and the discretion that local authorities will likely be given. It's very likely that we'll see fees increase if this bill comes into force. Number 7 is training for planning committee members. I don't know how many of you are familiar with planning committees. Members are local elected councillors that form a planning committee on behalf of a local planning authority. They are not at the moment required to undertake training. A lot of them do, I have to say, and I know that because I provide training to some of them. But that doesn't necessarily mean that the training is standardised over and across the country, nor does it mean that members actually listen to a lot of that training. And the idea behind this is that it's supposed to increase efficiency, transparency, accountability, and there'll be some form of regulations provided for by the Secretary of State concerning the type of training that members have to undertake. And members would then be prohibited from any involvement in planning decision making without a certificate of completion. So again, this is something that may be quite an effective route at streamlining the planning process and making sure committee members are making appropriate and proper planning decisions, but it ultimately remains to be seen as to how effective that's going to be in light of any regulations that we get coming forward. The next few changes, number 8 is an idea of a delegated national scheme to ensure greater consistency across local planning authorities. At the moment, different councils have, through their own constitutions, different scheme of delegation. So local planning authority officers will be able to entirely determine a planning application by themselves in some situations, but it does vary. The idea under this proposal is that there'll be some sort of standardised delegation scheme. And what's been considered is whether delegation should be looked at where an application complies with the development plan. So you've got a local plan. If it complies with those policies, it can be dealt with by an officer instead of going to committee. Or the default being with exceptions for departures from the development plan, or with a prescriptive list of exceptions. At the moment, we don't know, again, quite what that might look like. It will need to come through secondary legislation if this bill is passed and comes into effect. But ultimately, there will have to be a balancing act because compliance with the development plan is not always straightforward. And so even if the scheme of delegation suggests that it will stay with officers if a scheme or a particular application complies with the development plan, it's not quite clear how that will be enforced or actually put into effect. The next one, number 9, is spatial development strategies. And through an insertion of a clause into the Planning and Compulsory Purchase Act 2004, strategic planning authorities will be required to produce these new spatial development strategies. At the moment, we have systems of local plans which comprise core strategies, allocations, etc. The idea behind a spatial development strategy is that larger combined authorities or unitary authorities that consist of what would previously have just been one district council, for example, or borough council, are required to come together and deal with and create some overarching strategic policies that might set housing levels, for instance, or the type, distribution, or specific amount of housing. So again, this wouldn't be an idea of allocating specific sites or dealing with really detailed points, but there would be this overall strategic development strategy that would be in force. Number 10 is nature recovery, and some of you may have encountered issues with new nature issues, things like nutrient neutrality, water stress, and they've resulted in delays to development while strategic mitigation is being secured. And the key suggestion under number 10 is that Natural England may put into place an environmental delivery plan to provide conservation measures to address specific environmental impacts of development on certain environmental features through a levy. And that also means that certain sites would then be exempt from assessments, things like under the habitats regulations, if they fall within the environmental delivery plan. So it should speed up sites where there are issues with environmental matters. And the last that I deal with is development corporations. Current legislation allows for 5 different types of development corporation, all with different powers, remits and objectives, particularly around the provision of utilities, infrastructure and transport. And the new provisions in the bill are intended to provide greater clarity and flexibility for development corporations in terms of the variety, extent and types of geographical areas they operate in. So I pause at that stage. There's a potential swathe of new measures that are going to be brought in through this bill. Some of them are quite significant on a large-scale infrastructure level. Some of them are also quite significant for Town and Country Planning Act applications for planning permission, which will be made to local planning authority. And the key changes, I think, on the ground and in dealing with non-strategic infrastructure will be potentially higher fees, as I've said, potentially better committees that will be better trained through a standardised system. But again, let's see on that point. And quicker and more delegated decisions potentially if the government can work out quite how to justify and interpret and set out compliance with development plan and ensure that there's some sort of national consistency in that respect. So I'll pause at that stage, say thank you and pass over to Alan.
Thanks, Shem. Morning, everybody, and online as well. I'm a chartered town planner. I'm looking. Shem's looked at the legislative changes, and when I finish my little bit, we're going to have a discussion between ourselves, because I know a lot of people will be thinking NSIPs, nationally significant infrastructure projects. They're not going to involve what I do. They may well, simply because how they affect development and basically one of these things next to you, nearby. And I'm being involved in a lot of solar farm development at the moment, which falls, if they're large enough, fall within the NSIP regime. So they are actually important, and people need to know about them and the implications of them. Right, what I'm going to talk about. So Shem's talk about the legislative background and changes that are coming up. I'm talking about planning policy and the impact of changes which have already happened is having on the ability to secure planning permission for, I'm talking about housing in particular, but there are other elements as well. So when the government elected last July, were elected, part of the manifesto was a pro-growth, pro-development initiative in order to stimulate economic growth. And the government said that they were going to hit the ground running. And last July, Angela Rayner wrote to local authorities setting out clearly the intention to adopt ambitious housing targets, and they announced consultation on changes to Greenbelt policy to release land where necessary to meet unmet housing need. So you've got the two elements of it, demonstrating we need more housing. How are we going to achieve it? We release Greenbelt. So in December last year, as Shem has already mentioned, there is a revised national planning policy framework, the NPPF. Also last December, there were new housing land requirements which were issued for each local authority area. I better get to my notes because so in terms of Greenbelt, I mean, where we are at the moment, Greenbelt policy has been very successful. Everybody knows what it is. However, there have been murmurings in planning circles for a while that Greenbelt is too restrictive and prohibiting development when there is a legitimate need, housing in particular. I mean, to recap those who aren't necessarily familiar with policy, inappropriate development in the Greenbelt is not permitted unless there are very special circumstances to justify it. And that's a really high bar. There is policy advice in case law about how very special circumstances are defined and what factors are relevant. I mean, in my everyday work, people ask me, potential clients, I've got a site, it's in the Greenbelt, and they explain the circumstances. What are the chances of getting planning permission? My default answer is always none, or so negligible that it's not worth it. That's changed because of where we are now. So one of the changes to national policy was to introduce the concept of grey belt. So the grey belt is defined in the NPPF national policy. It's previously developed land, brownfield sites, or any other land. Well, what could that be? And grey belt should not strongly contribute to the green belt purposes of checking the unrestricted sprawl of a large built-up area, preventing neighbouring towns from merging into one another, or to preserve the setting and character of an historic town. Now, these purposes are actually set out in the NPPF, and the sort of long-standing, going back years. These purposes have been an established part of policy. The idea is that local authorities will undertake a review of their green belt to determine the areas that qualify as grey belt. But it can also be claimed by developers, landowners, as part of the justification for a proposal when making a planning application. So what is the policy for development on land that qualifies as grey belt? So the development of homes, commercial and other development is not inappropriate, bearing in mind that inappropriate development shall not be permitted, where all of the following apply. So you have to satisfy all of these. First, development would utilise grey belt land and would not undermine the purposes taken together of the remaining green belt in the plan. So it's not just, you're not focusing on the area around the site you're dealing with, you're focusing on the whole area. So if it's, in Trafford, shall we say, you're looking at all of the green belt in Trafford. Would development of this site undermine the whole of the green belt? And the answer many times is going to be no, it's not. Is there a demonstrable unmet need for the development you're dealing with? This is where the housing requirement comes in. The development will be in a sustainable location. That means, it's relatively close to shop services, employment, has accessibility by public transport or so. In other words, it's not a remote location in the middle of the countryside with no facilities around. And where applicable, development meets the golden rules. Now, the golden rules are that if you've got a housing scheme, they only apply to major development. And major development is for housing schemes of 10 units or over a hectare in land. So they don't affect small developments. But if the golden rules apply, you're required to provide an enhanced level of affordable housing for housing schemes. Necessary improvements to local or national infrastructure. So you've got to look at how the scheme could sort of facilitate, local provision, whether it's providing accessibility by footways or whatever for the general public benefit. the provision of new or improvements to existing green spaces that are accessible to the public. So in other words, if you're dealing with a large site, you've got to make provision for public open space there that's available for everybody. So Greenbelt policy has changed. If a proposal, there is no requirement to demonstrate very special circumstances where land is in the grey belt and there's a demonstrable need for the type of development proposed. And policy is changed by the definition of inappropriate development. Now allows a wider range of development to come forward in the Greenbelt. So overall, that's a significant relaxation of Greenbelt policy. Now, if that's the yin, I'm moving forward to the yang now of this. The housing requirements issued in December 2024, in most areas, the requirement is significantly higher than previously. Oh, let me just see how we're going. Right. I'm working without slides now, folks. I was going to do an illustration of housing, the requirement in the two Cheshire authorities, Cheshire East and Cheshire West and Chester. In Cheshire East, the old requirement was for them to deliver 977 new homes a year. The December 2024 requirement is that they should deliver 2,461 homes a year. So that's more than double the requirement. In Cheshire West and Chester, it was 532 prior to December, and it's now 1,914. So, I mean, that's triple what the requirement was. That is a very substantial increase in the requirement that they are, they've got to bring forward, which means they have to grant planning permissions to enable to deliver that. Now, housing land supply is a key input into meeting housing needs. National policy requires local authorities to maintain a 5-year supply of deliverable housing land. If there is a shortfall outside of the Greenbelt, a presumption in favour of granting planning permission will apply. It's also evidence, that shortfall, of a need in the Greenbelt. To put this into context, I mean, I did a quick Google search to tell me in 2025, the local authorities in the northwest of England with a less than 5-year supply of housing land. And, that is really important from a planning perspective in bringing sites forward. So there are the authorities with a very weak supply, that's less than 3 years supply of housing. There are, I had a slide for this, there are 9 authorities: Hyndburn, Pendle, Blackpool, Stockport, West Lancs, Wirral, Cheshire West, Chorley, and Westmoreland and Furness. So that's a very weak supply. And then there are a further 14 where it's estimated to fall below 5 years. So just briefly, Bolton, Knowsley, Preston, Tameside, Bury, Lancaster, Sefton, Trafford, Cheshire East, Oldham, South Ribble, Warrington. So I would say most of the authorities in the northwest of England will have a shortfall. They either have it or will have a shortfall in housing land supply, which creates the conditions for planning permissions to be granted. So this, combined with changes to Greenbelt policy, mean that there are opportunities for development, even on sites within the Greenbelt. This is not just about large sites. I mean, so far this year, I've been successful in securing permission on small sites and single plots in the Greenbelt because of these changes. So prior to the change in policy and the housing requirements, if I was asked about the chances of securing planning permission in the Greenbelt, I've already said, my default answer would be you're wasting time and effort thinking about it. That's, of course, unless there was something specific about the site that would in fact be a coat hook to be able to justify development. Circumstances have changed substantially, and where land can be justified as greenbelt and where there is a demonstrable shortfall in housing land supply, most places in the northwest, there is a reasonable, if not good, chance of securing planning permission in the greenbelt. As always, disclaimer, site-specific circumstances, will influence this. But as a general rule, if a site qualifies as grey belt and there's a shortfall in housing land, it is very worthwhile having a look at the potential for development. So thank you. I apologise that my slides didn't appear, my tables, and I've had to run them out, but not to worry. So Shem, we're going to chat now, if you'll bear with us. I mean, I've said about the NSIP, about it, people will be, in the audience here and online thinking this is not going to affect me because this is power stations and things like that. I mean, have you had any experience of sort of in everyday planning circumstances where NSIP schemes have impacted on individuals?
Yeah, so it's a good question, Alan, and I've been involved, like Alan, in quite a few solar farm NSIPs recently, so very large scale. Lincolnshire is a very good example because they've got a couple of decommissioned power stations. That means there's a lot of grid capacity. In practice, they are huge scale, and where you have especially more than one proposed somewhere close to another, the implications in terms of landscape harm, residential amenity effects on people who are living in the area, compulsory purchase of land, etc., are quite significant. So they sort of don't affect us until all of a sudden they do affect us because they're right next door. The other implication is, of course, the impacts it can have on meeting certain needs when you're bringing your smaller development along. So if you've got NSIPs coming forward and then you're also proposing smaller solar farms nearby, that might affect the extent to which there's some cumulative effects. So in practice, they affect our everyday lives when we're near one. The planning process is quite a long, drawn-out, complicated written process, but it's one that scrutinises it in a lot of detail because they're very significant. And then they also can affect when you're wanting to propose your own developments because they can affect cumulatively what might happen in a specific area. So yes, if you haven't come across one, it's helpful to know about their potential implications because they have quite significant implications both on a large national scale, but also in terms of smaller localities.
I just as an aside, I'm presently dealing with 3 solar farms. I'm objecting to them. 2 are not NSIPs; they fall below the threshold. One is an NSIP, and the process is different. Now, if you're objecting to a development, I'm dealing with 2 in North Yorkshire and 1 down in Somerset. If you're objecting to these, the processes are actually quite different, and the NSIP process, as an objector, is different to the normal planning process to get involved in. So, but it's important to be aware of them. I mean, just changing the subject, and we've talked about changes to legislation coming forward and changes to policy. I mean, clearly these are designed to facilitate development. I mean, as I see it, that there are elements of the bill and the proposals coming forward that will add cost to development. Do you think it will provide any more certainty that if you're bringing a scheme forward, that the money you spend on the planning process is more likely to give a reward?
Yeah, and I think at the moment developers are concerned because some local planning authorities can take a long time to determine applications. There are target determination periods, but it's not uncommon for developers to agree an extension because it might be favourable to them to try and reach a likely recommendation for approval before you get to a planning committee. So at the moment there are concerns. I think that increasing fees, although it's going to go to the developer ultimately as part of an application fee, The idea is that those fee increases would be ring fenced, so they would be only going towards planning determinations. And the advantage of that is it means that local planning authorities can actually meet their planning determination costs. And so, yes, it might be slightly more expensive for developers, but the strong hope would be that planning applications will be determined more efficiently, more effectively. There'll be greater resources. There'll be hopefully a greater number of officers looking at them. And that sits alongside with all the other proposed changes to scheme of delegation, for instance. So I'd anticipate that it's a positive thing and it will help speed up the process. But it's very much yet to be seen as to whether on the ground that will make a big difference.
I mean, resourcing is a big issue. I mean, if I meet a new client, invariably they'll say, this planning authority which I'm dealing with is the worst in the country. What do you think? And it's a bit like every planning authority that I deal with is under-resourced. You know, people don't want to do a bad job. I genuinely believe that. But if they haven't got the resources, if there aren't enough people, if there aren't enough experienced people in there to deal with planning applications, problems arise. I mean, the government announced back in July that they were going to fund an additional 350 planning officers as part of the big, drive to get more resources. That's less than one for every authority in England and Wales. It's not enough basically to get where we need to be. So either planning applications that are submitted, you've either got to weed them out so that people, the ones that don't matter, the sort of routine things are dealt with really quickly, really efficiently, and you focus on the really important ones. I'm not convinced this is actually going to help to be able to do that. What it should do is mean that if you go to make a planning application, the new scheme of delegation, the national scheme of delegation, will be very clear about when a planning officer makes the decision on an application and when the committee makes a decision. And if a committee makes the decision, it ought to be better informed than it is at the moment. That's my gripe. What else can we talk about?
I've got a query for you, Anne, because you mentioned that smaller site grey belt applications you could still get them over the line. I've dealt with smaller and larger scale grey belt sites. So I wondered if, in your experience, there's a difference in likelihood of that being granted in accordance with the new policy.
Right. I don't know whether people are aware of permission in principle. Permission in principle is a route to a planning permission, and it deals simply with the principle of development on the site. Where you have a small grey belt site, this is where I've been successful. The advantage of permission in principle, I go back a long way in my career. Once upon a time, if you were making an outline planning application, it could be nothing more than a red line on a plan, fill in the form, and that was it. That was your application. Permission in principle is very similar to that. You don't have to provide any technical reports with it. You are simply dealing with the principle of development. And the authority have 5 weeks to determine it. So it is very light on information. You're focusing on the suitability of the site for the development that you're proposing, and it's quick and easy. And then you deal with the technical aspects once you've dealt with once you've got that. And where you've got sites in the Greenbelt, this question of, do we satisfy all the criteria? Will the authority accept this as a grey belt site, or is there going to be a dispute there? An application for permission in principle is a really easy route and relatively cheap to sort that out. So that's where the smaller site, that's where I've had success. And permissions in principle were introduced in 2017, and I used them quite a lot early on when they were first introduced. One issue is that the market doesn't understand them. And so there was a sort of educating process. But now with grey belt, I think they're back into their own. They really have a purpose of helping to bring sites forward.
I certainly agree with that, and I think if you do own land which is green belt and you think, oh, there's a chance that this might be grey belt now, there are still quite a lot of hurdles to go through, and it's a bit of a complicated test because you start off with what's in the annex of the NPPF, which defines what grey belt land is. You look at all the purposes of the green belt, the extent to which it contributes, and then you work your way through some of the tests that Alan had on one of his slides, which is under paragraph 155 of the NPPF, which goes through the extent to which the site might affect the wider green belt, and then you look at meeting need, sustainable location. So as Alan went through, there are quite a lot of hurdles to go through on a grey belt site, even if you can persuade the local authority that it is actually grey belt. And I've dealt with lots of appeals where the local authority is saying it's not grey belt. So I think a permission in principle route is certainly an effective way to think about any grey belt site, rather than having to then go through all the technical matters and find out that you're going to have a dispute about the principle of development in the first place.
Great. I hope that's been helpful. I've enjoyed it. Have you?
Yeah, I've enjoyed it. Thanks very much for having us.
All right. Well, thank you. Thanks very much.
Thanks very much.
Thank you very much, Shem and Alan. I think that's a lot for us all to think about, and it will be really interesting to see how things pan out over the coming months and years, whether we get 1.5 million houses, baby, or... So that's all we've got time for this morning. As I said, if you've got any questions, do stick around afterwards, or drop us an email, give us a call. Our contact details are in the slides that you've got there. You will be able to watch this seminar again. It will be emailed to you with a link, or you can catch us on the YouTube channel, as always. So all that remains is to say, again, a big thank you to Alan and Shem for coming to join us, and to you all for joining us as well. And enjoy the rest of your day.